This is Professor Todd Shaw at the University of South Carolina, and this is a lecture for the course American National Government, POLI 201. This is topic 1D, and the title of the topic is the Madisonian model and a brief outline of the Constitution, of the U.S. Constitution. Now, the U.S. Constitution begins with the following words. We the people of the United States, in order to form a more perfect union, establish justice and ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Here I show you a picture of the rotunda of the National Archives, where the original copy of the Constitution of the United States is secured in a vault, a pressurized vault, or a pressurized display case where visitors can come and watch the Constitution. And each night, each day it is lifted to vision level, to viewing level, and then they bring it back down to the archival level to ensure that the document remains secure. But the Constitution, as many jurists have said, is a living document. Its promise is in. The words having relevance and meaning to us today. But in this lecture, I'll give some discussion about the Constitution's history and the logic behind the document. So let's talk about the logic and outline of the Constitution by understanding James Madison as the father of the Constitution, or what I'll refer to as the Madisonian model. How did Madison's political philosophy and his worldview, his view of pragmatic politics, frame what became essentially the basis, the template document that would emerge as the model for the U.S. Constitution? And then I'm going to go through a brief overview of the Constitution of the United States. And although James Madison is known as the father of the Constitution, I'll give a brief shout out to Alexander Hamilton. The Federalist Papers that Madison, Hamilton, and John Jay penned are among the most important political treaties of American political thinking, and some would say are very important political treaties of the Western world. The Federalist Papers made an argument for the ratification of the Constitution by the several states. And the Federalist Papers have been cited at least 300 times in Supreme Court decisions, just to indicate how important these papers were, not only in that day of passing the document, but to our thinking and understanding and interpretation of the document today. And by the way, Alexander Hamilton wrote the greatest majority of the 85 essays found in that particular treatise, that particular volume of essays that defended the passage of the Constitution. Just a little something to keep in mind. So, as I always do, I start off with an opening story and then an opening quote. My opening story is actually something that I came across in just the last week or so. So a relative of mine, actually my niece, recently sent me a note, and she sent me this text or Facebook message, and asked me to send it to 20 more friends in the hopes that it would go viral. Now, the basic gist of this particular note was that the contention that the U.S. Congress, members of the U.S. Congress, the Senate and the House of Representatives, have the ability to pass laws from which they themselves are exempt. That there are ways in which the powers implied by the implied powers of the Constitution, the implied congressional powers, means that the Congress can pass laws, at least in certain instances, that don't directly relate to them. We'll unpack this more in class. But here is the gist of what was my niece and these various folks are proposing as the 28th Amendment to the U.S. Constitution. And it reads, Congress shall make no law that applies to the citizens of the United States that does not apply equally to the senators and or representatives. And Congress shall make no law that applies to the senators and or representatives that does not apply to the citizens of the United States. Now, I bring this up when you think about it, in the 230 or so year history of the United States, we've only had 27 amendments to the Constitution, and after the original 10, which you know is the Bill of Rights, we've only had 17 amendments to the U.S. Constitution. Kind of remarkable in a nation of 400 million people at this point. And so, why? What is as Lowy et al. Say in our textbook, what's the path dependence or the historical principle that would explain why so few amendments? And some of it has to do with the structures of the rules and the institutions, how the rules would have been structured, that it's very kind of hard to pass an amendment to the Constitution. In the 20th century, there have been nearly 20 proposed. And all total, there's been 9,000 proposed. But as Lowy and his co-authors say, many have been proposed, but few have been chosen. So we'll unpack this at the end of the lecture, particularly when we think about the amendment process to the Constitution. So here's my opening quote, and it comes from James Madison. We're going to be citing James Madison quite a bit throughout this lecture, because again, he's sort of known as the father of the Constitution. James Madison lived between 1751 and 1836. He was a Virginian planter, a politician, a political philosopher. In his demeanor, James Madison was a sort of very small, slender man with a very sort of shy personality. It was said that at times he spoke so very softly during the Constitutional Convention that the delegates implored him to speak up. But behind that shyness and reserve was a man with quite a bit of genius in terms of his political thinking. And he and Alexander Hamilton, at least up in this period of American political history, were strong political allies, particularly as Federalists. Now, James Madison, as the father of the Constitution, had some broad political thoughts or broad political theory about how society works. And he says that factions, divisions in society, may be troubling, but they're unavoidable. That a society, particularly one as large as the United States would become, a republic as large as it would become, is bound to have divisions. And it's unavoidable, particularly in a society where people have the freedom to be free, to pursue some degree of individual rights and liberty. He said in Federalist Paper number 10, by faction I mean a number of citizens, a majority or minority adverse to the rights of other citizens. So he says, these divisions are inevitable. But what do you do with these divisions? You can't get rid of these divisions. What do you do with them? How can you use these divisions? In Madison's view, almost in a sort of scientific way of one passion, one ambition, to paraphrase him, checking another. Madison also had a view of human nature where that said, if men were angels, they would be in no need of government. He had somewhat of a cynical view. He was not of the view that necessarily human beings did the right thing. And since they don't always do the right thing and frequently don't do the right thing, how do we structure government all the same to benefit the largest number of persons and not trample on the rights of individuals and minorities? So the Madisonian model had a couple of premises to it, and we're going to lay out those premises in order. First of all, remember that he, among the other framers, were not supporters of pure democracy. They preferred the Republican principle. So pure democracy, meaning direct democracy, as I've used that language in a previous lecture, where people directly represent themselves in an assembly or body and deliberate for a particular outcome. He says that's very kind of problematic to do. He disagreed with a contemporary, the Baron de Montesquieu. They would argue that large republics are difficult or nearly impossible. Madison said no, large republics are possible, but you have to base it on the Republican principle. Representatives representing the people through elected representatives, not through direct election or direct representation. And there's a pretty strong reason why Madison and others had their suspicions. Remember I talked about Shays' Rebellion. Remember I talked about the anarchy, really the near anarchy of the period where the United States was first founded under the Articles of Confederation, which were very, very weak procedural rules, a very weak form of constitution, even though it was the first constitution. Madison's thinking, however, about pure democracy versus the Republican principle went as follows. Also said in Fairless Paper number 10. Such democracies have ever been spectacles of turbulence and contention. This is what he means by pure democracies. And incompatible with the personal security or the rights of property. There are sort of several examples we might think about with regards to this idea of pure democracy leading to chaos. One example among just a multitude of examples might be the Paris Commune, the French Paris Commune of 1871. It was a rebellion or insurrection in Paris against where a group of insurrectionists, resistors, directly resisted the French government at that time. It was sparked due to France's defeat in the Franco-German War of the period and the collapse of the Second Empire, 1852 to 1870, of Napoleon III, the successor to Napoleon. About 200 insurrectionists were killed, along with 750 government troops in the aftermath of the Commune. The government took harsh repressive action. About 38,000 people were arrested, and 7,000 were deported. That's a 19th century example. A 20th century example, maybe you're a little too young to remember, under the Clinton administration, the Branch Davidian or Waco siege by the federal government, again under the Clinton administration and under then Attorney General Janet Reno. It was a 51-day standoff with a sect, a radical sect of the Seventh-day Adventist Church, the Branch Davidian Church, founded by David Koresh, and federal agents raided the compound for fear that they had large stores or caches of weapons and were going to prompt a violent attack upon government sources. It was in Waco, Texas. Nearly 80 people were killed. And again, this was all about this idea of the Alcohol, Tobacco, and Firearms, the ATF Bureau, having a arrest warrant against Koresh and him resisting the federal agents. And you can see the compound is literally in flames with tanks rolling through as a means to take to enforce this warrant. So when there is pure democracy, grassroots democracy, when there is a presumption about the ability to govern oneself outside of government, Madison and others would be frightful or quite concerned about the prospective outcomes. So the Madisonian model was, or is, a model sort of derived in this period of the late 18th century, the late 1700s into the 1800s. Remember, I talked about in a previous lecture that this was a period of the English and Western Enlightenment, where scientific revolutions as well as philosophical revolutions were occurring, whether it be sort of the everything from the inventions of Benjamin Franklin and taming lightning and deriving devices as simple as spectacles to the sort of philosophical movements forward, whether it be the thinking of John Locke or certainly the thinking of someone like James Madison. So this Enlightenment period had a belief in scientific principles and the ability to create a balance similar to the scientific balance of the universe, to the laws of the universe. So how did the federal constitution sort of achieve a balance between interest or factions? How do you set one ambition against each other in a constructive way that maintains order and protects liberty? On one side, you certainly should have some degree of popular legitimacy, that if a government does not have some way in which it is rooted in popular rule and popular legitimacy, yet calls itself a government of consent, that sounds a little hollow. So to be democratic on some level is to have some degree of popular legitimacy rooted in the idea that you do in fact have the consent of the governed, at least on some level. But what counterbalance popular legitimacy would be limited popular control. So the people do give their agreement that the government has the authority and legitimacy, moral and political legitimacy, but it does not mean that the people are involved at the mass or popular level in all aspects of government and of the selection of the elected officials of government. Then on one side you have sort of separation of powers, that if you had in our federal system of having three branches of government, each having a slightly different domain of power, and that the powers that you have these no one set of powers vested all in one government, so or all one branch of government. So the president, the executive branch, having the power to implement the laws, to enforce the laws, to some degree interpret the law, but Congress passing the law, legislating, having the powers of the purse string. Federalism is another sort of force or counterweight, if you will, in bringing about the check on interest and in check with regards to factions. Federalism, that you have a sort of a sovereignty or a division of sovereignty, a division of authority between the federal government and the states. Again, another sort of weight to check ambition and to balance ambition and faction against another, again, one faction or interest against another. Then checks and balances, quite literally. And we'll further discuss sort of checks and balances in the sense that not only are powers divided, but one power can stand in contrast to another, to check the power of another. The president doesn't have the power to veto legislation within Congress or veto legislation passed by Congress. The Congress has the ability to impeach the president. Again, one check these checks help to bring about some degree of balance and accountability. All right. So let's talk a little bit more about the Madisonian model and go over each of these broader concepts. So let's talk about the question of popular legitimacy. One example of popular legitimacy would be the direct election of the House of Representatives. So it is literally the people's house. And as Madison would say, it's essential to a Republican government that it be derived from the great body of the society, not from any inconsiderable proportion of a favored class of it. So remember, from the Great Compromise, the House of Representatives is that body where the states are represented, or actually the states are represented in the sense that they are represented on the basis of population. Now, the formula for apportioning the seats, or the degree of apportionment of how seats are divvied out between these various electoral districts, have changed, but the basic principle remains the same. Also, the election of the House members every 2 years. So the fact that every 2 years there is an election, so there's a degree to which and we'll talk about the incumbency effect. It does matter of being an incumbent as to whether or not one is elected again. But there is the prospect of having to to bring about greater levels of accountability, because the representative has to return to the people and to get the people's consent to move forward. Then the eventual ratification of a Bill of Rights. Madison was a strong Federalist, but eventually he argued for this Bill of Rights. In fact, Alexander Hamilton initially said, it's not necessary. We already guarantee limited government. Why do you have to stipulate the people's rights in that regard? And in fact, there are some rights already stipulated in the Constitution in those first 7 articles. But Madison began to embrace the view that, in fact, a Bill of Rights is necessary. And you didn't actually have all states come into the Union until there was a Bill of Rights by 1791. It was the last step, and is actually the way in which the anti-federalists, if you remember that previous discussion, finally had at least some of their concerns allayed about the federal government being entirely too powerful, power being too centralized in the hands of this national government. All right. Now I'm showing you this picture of the White House lawn peeking through the gate, and I'm sure I put this magnifying glass up to it because I want to convey this notion of distance. That as much as we might refer to the White House as the people's house, that the president, it was by design that the president be somewhat removed from the people. In fact, when we get to the discussion of the presidency as an institution, we'll talk about the particular leadership styles and examples of certain presidents. George Washington set an important example in the presidency. George Washington was a brilliant man, but he was often said he was aloof, that he had a sort of somewhat a subtle aristocratic bearing, that he chose not to shake hands and to be too familiar with individuals. And he carried this not only in his military life, but in his life as president. But it was this idea that the president should be removed from the people in some regard. And we'll talk about exactly how you proceed with that. But that there needs to be some figure who's not simply given to the whims and passions of the people, but can step back and represent the national interest. Now, just that, thus the idea of sort of distance. So let's talk about examples of limiting popular control or limited popular control. The election of senators every 6 years as opposed to every 2 years. So the Senate is literally modeled after the idea that you need a body that has a memory, that you need a body of the government within this bicameral system where the persons elected to that body have a degree of seniority, a degree to which they are not so overly concerned about the accountability of elections every other year that they can't take the long view. George Washington thought of the Senate as a metaphor of a saucer and a cup of tea. And he says you pour the saucer, the reason why we have tea saucers is it was the practice that you would pour the tea into the saucer, into the plate under the teacup, to let it cool, to cool it off. That's literally what they would do, is pour it out and pour it into the saucer, and then you would pour it back into the cup. And he says the Senate is that. It cools the passions, slows things down, has some degree of deliberation, before one proceeds with an outcome, and having the ability to be elected, and that the Constitution provided that 1/3 of the Senate from the very beginning is up for election. So 2/3 of the Senate is not worrying about election every 2 years. And so there's one, but there is every 2 years, 1/3 of the Senate being mindful of election. So this provides a different electoral connection and a different connection to the people. And actually, until the passage of the 17th Amendment, the Senate was in fact selected by, not by the people, but they were elected by state legislatures. So the indirect election of the Senate by state legislatures until the 17th Amendment was another means to create this cooling passion that would provide some brakes on too much popular control. Then the indirect election of the president. And we're going to spend a decent amount of time explaining the complexity of the Electoral College, because as true in the 2016 election, the 2000 election, and we can go back with various other examples, the Electoral College is not a particularly democratic institution on some level. And when I mean democratic, meaning that the popular vote and the electoral vote can sometimes disagree and have sometimes disagreed. But the Electoral College's purpose is not necessarily to perfectly reflect the popular control of the people, but is to provide stability. There was the idea, in fact, that the framers believe that the people would not be well enough informed, or that passions could overtake, and that a majority might capture the presidency and thus the highest national office in ways that were destructive to the Union. But we'll talk about that, and certainly we'll also talk about the ways it's been amended with the 12th and the 20th Amendment. Then the appointment in lifetime terms of members of the U.S. Supreme Court. And Alexander Hamilton said that, well, because the Supreme Court is the weakest of the three branches, it doesn't have an army or navy to call out. It has to depend on the executive branch to enforce its verdicts, its outcomes. It isn't popularly elected, clearly. It's appointed by the president, and then the president forwards his nomination for the advice and consent of the Senate that confirms nominees. So since it does not have this ability to have this direct popular connection, but it is and has become in the case of the Supreme Court, the supreme interpreter of the supreme law of the land, that there's a need to have some distance so that these wise judges have the ability to give opinions, not based upon whims and passions, but upon legal precedents, upon those things rooted in constitutional principles. All right, next aspect of the Madisonian model, the separation of powers. It means the division of authority between the legislative, executive, and the judicial branches. And federalism is a term we're going to give some more discussion to in the next lecture quite a bit. But broadly speaking, federalism means a division of authority between the federal, national government, and the state governments. And we'll discuss this notion of sovereignty, the ability to have supreme power in one's realm of supreme power over a particular domain. In what ways are states sovereign, thus independent of the federal government? How is the federal government supreme in some areas of political life and some domains of governance? Now, hope you don't get tired of this click-click sound. But I'm showing you this clock because I want to convey to you the idea that I said earlier about Madison and political philosophers of this period, of Western political philosophers of this period, thinking that the natural world, the universe, the cosmos, provided a model. The laws of nature, in other words, provided a model for human behavior. Think of a clock. Now, I'm not thinking of a digital clock. I'm here letting you hear the tick-tock of a clock. an analog clock, a clock where you have to have cogs, a mechanical clock where you have the cogs of the wheels of the clock turning against each other, providing the friction that turns the hands. And so, literally, how do you create a tension, one thing rubbing against the next to create a certain outcome? And Madison then sort of thought about this as sort of the ways in which you can look at the natural universe and the precision of the natural universe and extend it to what is true in life. So by checks and balances, he reasoned, the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others. In other words, it's not enough in Madison and the framers to simply divide the powers between the separate branches. It's also important to ensure that these powers were in symmetry or were complementary to each other. Again, the metaphor, the cogs and springs of a clock are working in unison, partly because the friction between components creates the necessary energy to move the system forward. Okay, you probably are tired of that click, so I'll get rid of it. So, let's think about this notion of checks and balances and examples of checks and balances. So, for instance, one example of one constructive tension in our constitutional system is bicameralism. Bicameralism, two or divided, cameral or body. So a legislature that is comprised of two bodies. In our case, a lower house, a lower chamber, a House of Representatives, and an upper chamber, the United States Senate. And Madison and the framers wanted sort of a legislative process that was slow and deliberative. Again, as I said, this idea that George Washington spoke of the ability to sort of cool passions so that you didn't sort of simply rush to conclusions based upon sort of popular whims of the day. Another example is the Senate's advice and consent authority. Oh, so let me explain. With the bicameralism, so you have to pass legislation in both houses of Congress. A law only becomes a law when passed by both houses of Congress. These congressional houses have to reconcile legislation, and so it has to be debated upon, go through the committee structure, be voted upon in each house. And then, as we'll talk about in the legislative process, you come up with a conference committee if there's disagreements between the two. That's a very incremental, deliberative process. Another sort of check or balance is the Senate's advice and consent authority, that the president can't simply appoint his cabinet or her cabinet, simply can't appoint judges, simply can't pass treaties, but the advice and consent of the Senate, that the Senate is that upper chamber of these individuals with longer terms and supposedly, of course, longer term views that have areas of expertise, and thus that you have to confer with the Senate. In earlier periods, you would have senatorial courtesy, where the president would speak with a member of the Senate or get some sense of a member of the Senate and asking to appoint someone from their state to a particular office or particularly to a member of the Supreme Court. So that advice and consent means the Senate has to give the president the go-ahead, or you don't go ahead with many appointments. Then the presidential veto. The president then can push back against the Congress and veto what she or he sees as necessary in terms of legislation. And we'll unpack the veto more when we get to the unit on the presidency. And then the Supreme Court doctrine of judicial review. As Lowy and his co-authors of your textbook originally said, this power originally, you really can't find it in the Constitution per se. It is a precedent set by Supreme Court Justice John Marshall, and we'll discuss how Marshall came about this notion of judicial review. But what does it simply say? Well, if the court has the ability to review and to declare whether a law is legal and or constitutional, it has the ability to declare things unconstitutional. Now, Alexander Hamilton actually does make reference to the judicial review concept, and his thinking in the Federalist Papers was helpful to Marshall in his thinking. So even though it was not the language not explicitly found in the Constitution, the ability for the Supreme Court to check laws passed by the legislature or to check the administrative procedures or outcomes of the executive branch is again another aspect of this check to create balance. All right. So let's talk about a brief overview of the Constitution. Here I'm showing you George Washington's original cabinet and the ways in which that cabinet of original 4 has greatly expanded now to 13. But again, the principles have held the same. Although George Washington initially and several successive presidents after him did not deliver an address to Congress in the State of the Union address, not until recently within the 20th century did you have did it become a popular precedence for the president to appear before Congress in person. But there is still this idea that the president has to be introduced and invited to attend Congress. He does not simply walk in. So there are certain aspects to our Constitution that remain the same across the ages, even given that the implementation of some aspects of the Constitution have changed over time. So, the legislative branch, Article 1. And there is a very specific reason why the very first article in the Constitution of the United States is the legislative branch. Because the framers of the Constitution wanted the Congress, the people's representatives, to come first. That's why they have the power of the purse. That's why taxation, all laws begin and have to be passed by Congress. That they have the power of impeachment. They wanted a very energetic, if I can use that word, National Assembly as the heart of government. Now this balance has changed over time, and the presidency and the bureaucracy has become quite powerful, but that was certainly the intent in naming it the first article. So the framers thought very specifically about the powers of Congress in the states. So Section 8 lists some of the powers. Article 1, Section 8 lists some of those powers. To collect taxes, to borrow money, to regulate commerce, to declare power, to maintain an army and navy. They are what you might call the expressed or the enumerated powers of Congress. However, there is also the elastic clause or the necessary and proper clause to demonstrate that Congress had the right to be activist about its enumerated powers. In other words, whatever did not immediately flow from the enumerated powers does not mean that the Congress didn't have the right to in fact, take on this power, pass this law, if it is in the good of the nation. Then there's the limits on national governments and powers, so found in Section 9, including the right of habeas corpus. And this articulation was why most delegates felt there was no need for a Bill of Rights. In habeas corpus, the fact habeas corpus is the right for one to know what you are charged with, that you cannot simply be arrested without charge. It was limits on state governments are found in Section 10, mostly dealing with the federal government's exclusive power over money and interstate commerce. States can't just simply void contracts, as was the problem under with Shays' Rebellion, or resisting simply tearing up debt, that the sanctity of the contract applies. The executive branch, or the presidential article, is Article 2. And in Article 2, you have sort of the ways in which the president has certain exclusive powers, that the president has wide discretion in the area of foreign affairs, and the conduct of foreign affairs, even though Congress elects or passes treaties. And then you have sort of a certain independence from the people. That the president has a sort of fairly wide berth in appointment of cabinet officials and personnel to the executive branch. And we'll unpack this more as we go. The judicial branch, particularly the Supreme Court, or Article 3. So, it is true that the Supreme Court has supreme judicial authority, and that it is a Supreme Court over all courts in the land, not just of federal courts, as is stipulated in Section 2. Now, later on, we'll discuss further the judicial review, particularly when we get to discussions on the Supreme Court. And we've got more unpacking to do. But there are other stipulations in the Constitution, whether we're talking about the powers in terms of national unity and power. In Article 4, the Supremacy Clause, that states the Constitution of the United States is the supreme law of the land. The Full Faith and Credit Clause, the Full Faith and Credit Clause, meaning that in fact states have to accept each other's contracts in full faith and credit. If you're married in one state, that marriage license applies across states. And the Elastic Clause, that speaks to the powers that the Elastic Clause, or the powers that in fact may not be implied or expressed, but are not in direct contradiction to the Constitution, and thus should be or are in the realm of Congress to do if it's in fact in the national interest, and courts declare that in fact these powers are constitutional. The Constitution also guarantees that state governments will have a Republican form of government, and uses specifically that language. And so unpacking that need for a Republican form of government says that in fact, one can't have a dictatorship in the state of Iowa. One has to guarantee that in fact there is a representative or elective government. So this is just sort of a broad swath of the constitutional provisions, 1 through 3, and then other aspects of 5 through 7. But again, as we said earlier, you have sort of the separation of powers being critically important, and the a broad sort of concept of the separation of powers, as we said earlier, about no one branch of government having supreme power across a particular domain. Let me see if I can find that important quote by James Madison. And James Madison said of the separation of powers, he says, the accumulation of all powers, legislative, executive, and judiciary in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny, if one is both judge, jury, and executioner. In this respect, Madison and the framers were following the thinking of Baron de Montesquieu, who lived between 1689 and 1755, who believed that such a balance was indispensable defense against tyranny. We'll talk further about federalism, and we'll talk further about the Bill of Rights, but these are also other elements found within the Constitution. Now, let's talk about sort of the process of amending the Constitution. It's a little complicated. The Constitution, before I get to amendment, I'll just mention that the Constitution was ratified by 9 of 12 states. The Constitution was ratified in 1789 when at least 9 of the 13 states, did I say 12? Sorry. 9 of the 13 states voted to join the Union. Unlike the Articles of Confederation, or actually in contradiction to them, the Constitution did not mandate unanimity. All but 2 states remained outside the Union, among them was Rhode Island, until 1791 when the Bill of Rights was satisfied.
And again, I remind you that the principal divide at that time was between the Federalists, or actually the Nationalists, and the Anti-Federalists, or those who assumed a unfortunate label, but actually were Confederalists in the old sense of the Articles of Confederation. The two sides are the very beginnings of our political system. And we'll talk about that when we get to our discussions of political parties. So let me give you just sort of a shorthand method of remembering the various routes to amending the Constitution. And you could draw yourself a diagram, but you could also refer to figure 2.2 in your textbook, where on one side, on the left side, you might say, okay, what do you need from the national government or Congress? What do you need from national conventions? If these national conventions, broadly defined, if a national convention was ever called, it has not been, and we don't know whatever would be the case if we did, but if it was called, what would you need? Then on the right side, what do you need state legislatures to do? What is the threshold for passage within state legislatures and then within state conventions? So the route that for the vast majority of amendments that have occurred in the United States has been a 2/3 approval of both houses of Congress and 3/4 approval among the state legislatures, among 3/4 of the state legislatures of the U.S. And so that is a route we know the most about. And Lowy et al. Referred to that as Route 1. Route 2 has been taken in at least only one other instance, if I'm correct, and it's the National Congress, or the Congress of the United States, approves a proposed amendment by 2/3 of approval of both bodies, and is approved by 3/4 of the conventions held within states. So that's Route 2. The routes we have not taken, or you can think of it as the roads less traveled, less taken, is a national convention that would, in effect, require 2/3 approval of those attending that national convention, and then 3/4 approval by state conventions, or a national convention, 3/4 approval within the national convention, and 3/4 approval within states. It's not actually clear that the routes 3 and 4, 1 and 2 are taken, 3 and 4 have not. 3 and 4 you couldn't call that national convention, and like the Constitutional Convention of 1787 in Philadelphia, dispense with the Constitution of the United States. So it's an intriguing possibility. All right. Next, I'm going to conclude by just giving a broad summary to the various amendments to the Constitution of the United States. And we're going to pull from tables 2.34 of your Lowy text. So I'm not going to read through this extensively, but I wanted to at least give some characterization, and you can go back and study it in your text. That, as Lowy says in the text, there are about 4 broad ways the first 10 amendments of the Constitution protected the rights of citizens. So it put limits on Congress. If the First Amendment, Congress is not to make any laws establishing the religion or abridging the freedom of speech, press, or assembly, or the right to petition the government. To limits on the executive, the executive branch, tongue-tied, is not to infringe on the right of the people to bear arms, is not to force people arbitrarily to let soldiers live in their houses, is not to engage in the search or seizure of evidence or to arrest people without a warrant, Limits on the courts. The courts are not to hold trials of serious offenses without provision for a grand jury or a petite jury or a speedy trial or presentation of charges, etc. Or limits on the national government. All rights not enumerated are reserved to the states or to the people. Amendment 9 and 10. Then here are a few amendments that expand the definition of citizenship. And this was important to our discussions, of course, in topic 1.b. So whether we're talking about a national definition of citizenship as was articulated by the 14th Amendment, extending the rights for all to vote regardless of race. The 15th Amendment, extending the right of women to vote. The 19th Amendment, extending the rights of residents of the District of Columbia. The 23rd Amendment, the 24th Amendment, extending the right of all classes of people not to have to pay a poll tax. 24th Amendment and the 26th Amendment, extending the rights of folk your age, 18 years and over, to vote. Then here are the amendments that redefine the electoral process and how individuals assume office. So whether it's provide a separate ballot for the vice president in the electoral college or penalize states for depriving freed slaves of the right to vote, or provide for the direct election of senators or shorten the term between elections and inauguration, or limit the presidential term or provide for presidential succession in case of disability. And then expanding or limiting the power of government. Limiting the jurisdiction of federal courts over suits, limiting slavery and the rights of states to allow property in the forms of persons, 13th Amendment, establishing due process law in state courts, establishing the national power to create an income tax, and limiting Congress's power to raise its own salary. All right, so here's the terms I want you to keep in mind for this section, if you're still with me. Oh, okay. Maybe you are. Okay. So I want you to think about the concept of the Madisonian model. How would you define it? What is the executive branch? What is the legislative branch, the judicial branch? What is bicameralism? What is the separation of powers, checks and balances? What are the expressed and enumerated powers, necessary and proper clause, or the elastic necessary and proper clause? What is the supremacy clause? Concurrent powers, let me stipulate this because I didn't bring it up in my notes, but concurrent powers are those powers held by both the federal government and state government. So a perfect example of concurrent power is the power to tax. The federal government has a federal income tax, but state governments have state income taxes. So that's just one of several examples. Then the process of judicial review, the elastic clause, the full faith and credit clause, and the stipulation that states have to have a Republican representative form of government. Review questions. Okay, I think you're still with me, right? Okay, so first review question. What is meant by the Madisonian model, and discuss how the Constitution counterbalances competing powers? What are the first three articles of the Constitution, and how does the Constitution provide for a strong but still limited federal government? What are the various routes to amending the Constitution, and what are the only routes that have been used? And lastly, how would you apply the principles of politics, especially the historical principle, to describe why there have been so very few amendments to the Constitution in more than 200 years? All right, this concludes my lecture for topic 1D. Have a good day.